Welcome back. We are live now with our trial expert analysis with Carl B. Grant. And Carl, two other salient points in the courtroom. Well, one of them had to do with some ballistics as they were entering those guns into evidence. I want to take a quick listen to that and then get your thoughts.
This would be the magazine which I removed from this rifle on the video, and the ammunition which it contained.
All right. And what kind of ammunition is that?
It's head stamped S&B 300 blackout.
All right. And do you know the specific brand and make and caliber of ammunition that was used to kill Maggie Murdaugh?
The head stamps on the shell casings at the crime scene was S&B 300 blackout.
Same thing?
Yes, sir.
Now, that's not saying that they have the murder weapon, but how compelling is that in terms of connecting the dots?
Well, it shows same gun, same ammunition, so obviously there's going to be some power imputed to that in the same location, in the same house. Mm-hmm. So that's going to be some evidence for the jury to consider. But I think the most compelling thing is really going to be, though, have you established that you have the gun that committed the crime? That's what we normally argue. Mm-hmm. You have to prove to me, sir, ma'am, that you have the gun that committed the, that's what ballistics, that's what it's all about. Mm-hmm. To establish that this is the weapon that killed the defendant, excuse me, the victim. Mm-hmm. If it wasn't the weapon, then how is it relevant? And that's the argument made by the defense counsel. And so that's going to be an issue. I know that's going to be an issue that's going to come up, especially now that these weapons are actually going to be going into the jury room. And let me also say this. When it comes to evidence and documents and everything being admitted in evidence, that's a very important point as far as procedure. Let me tell you why. The moment the defense decided to admit any evidence, they lost the right to what we call last argument to the jury. The only time the defense gets last argument to the jury is when they present no defense whatsoever and admit no affirmative evidence on their behalf.
Wow.
The moment they admitted one exhibit on behalf of the defense, they lost the right to last argument. And that's a very important strategy in a criminal trial.
And why is that so important?
It's so important because you're the last voice to speak to the jury. And if you have a compelling and a persuasive demeanor, you can sometimes convince that jury that it is what you said it to be, because naturally you're the last voice that they've heard.
And Carl, as we wrap up, just casual observers, you don't need to have a legal degree to make this observation. It seems the case is building. Testimony is becoming even more compelling as we get into this. So you have to wonder, what are we leading up to?
Well, here's the thing. There's a lot of evidence that they're presenting, but at the same time, the question that I mentioned earlier in an earlier interview is the prosecution must prove its case by competent evidence. Not how much you have, but the quality of what you have. That's right.
All right, well, we'll continue to evaluate that each day here on WYS News at 5:30.